Let me tell you about two people who used to be friends before they formed an LLC together. I'll call them Wednesday and Enid. They started candle business together. Great product, real audience, genuine enthusiasm. At first, they split the work pretty evenly, but over time, Enid ended up doing maybe 70% of the day-to-day work, and Wednesday was doing 30%. Enid wanted to bring on a third partner who had some cash to invest. Wednesday said absolutely not. Enid wanted to reinvest the profits back into the business to fund growth. Wednesday needed to pull her share out. And eventually, Enid said, "I want to buy you out. What's your share worth?" And they had no answer to that question. No agreed upon formula, no process, just two people who used to be close friends now sitting across from each other with a lawyer on each side, trying to figure out what their agreement meant. Except there wasn't one. This is not a rare story. I have had so many consultations start with some version of, "We had a handshake agreement," or "We figured we'd work it out as we went, and we trusted each other." And every single time, I think the same thing. If you had just spent a few hours with an attorney before you started, you would not be spending months, maybe years, many thousands of dollars trying to clean this up now. Today, we're talking about operating agreements, what they are, what they do, what happens when you don't have one, what absolutely has to be in yours. The most common mistakes I see, including the ones that will genuinely ruin a friendship or a business. And at the end, I'm going to answer the questions I hear most often. If you have an LLC, whether you formed it yourself online or had an attorney or CPA set it up for you, this video is for you. Even if you're a solo business owner with no partners, stay with me because I'm going to explain why single-member LLCs need operating agreements too and what happens if they don't have them. I'm Julie King from King Patent Law, and buckle up because this might be a bumpy ride for those of you who aren't familiar with LLC operating agreements, but I promise things will be smooth at the end. An operating agreement is a legal contract that governs how your limited liability company, or LLC, is run. It's the rule book for your business. It covers things like who owns what percentage, how decisions get made, how profits and losses are distributed, and what happens when someone wants to leave, whether you can force someone out, what happens if someone dies or is incapacitated, or how you bring in new members, and what happens if the business closes. Every state allows LLCs to have operating agreements. Some states require them. Most states allow them to be oral, meaning not written down anywhere. But that should immediately alarm you because an oral operating agreement is functionally an invitation to dispute, because who can prove what it meant, right? Some states do require a written operating agreement, even for a single-member LLC. But even in states that don't require one, you should always have one, in writing, signed by everyone. Here's something about LLCs I want you to understand. An LLC is an incredibly flexible as a Here's something about LLCs I want you to understand. An LLC is incredibly flexible as a business structure. That's one of the reasons it's so popular. Corporations are more rigid. There are more rules set by state law that corporations have to follow, and there's not a lot of room for customization. LLCs are different. The law essentially says, "We will give you some default rules, but your operating agreement can override most of them." You can design your LLC's governance almost any way you want, as long as you put it in the operating agreement. You can also have some flexibility about how you're taxed. That flexibility is a feature, but it also means that if you don't specify, you fall back on the state's default rules. And the state's default rules were not written with your specific business in mind. Let me give you one quick example. In many states, the default rule for an LLC is that profits are distributed equally among all members, regardless of how much work each person does or how much capital they contributed. Now, if Wednesday put in $20,000 and Enid put in $5,000, but they have a 50-50 ownership split, the default says they get equal shares of the profit. Now, that may be exactly what they want, or it might be the source of enormous resentment. The state does not care which outcome is right for your business. Your operating agreement does. Now I want to speak directly to single-member LLC owners, but multiple-member LLC owners need to pay attention as well because these issues, damn it. Now I want to speak directly to single-member LLC owners, but multiple-member LLC owners need to pay attention too because these issues apply to you as well. I don't have partners, so I don't need an operating agreement. Well, in most states, that is legally true. Conceptually, however, that is wrong. And here's why. First, the whole point of an LLC is limited liability protection. That protection can be stripped away if a creditor or a court decides your LLC is not really a separate entity, that it's just you doing business with an LLC label slapped across the top. That's called piercing the corporate veil, which is as dramatic and painful as it sounds. It means that you lose that liability shield an LLC provides, and your personal assets like your house are at risk. One of the factors courts look at when deciding whether to pierce the veil is whether you actually operated like a real business entity separate from you as an individual. Having an operating agreement is evidence that you did. Second, if you want to open a business bank account for the business, and you absolutely should do that, many banks will ask you for your operating agreement, not your articles of organization, the operating agreement. Why? They want to see who has the authority to open the account. Now, for single-member LLCs, this may seem silly, but banks are heavily regulated, and they may have internal rules requiring them to check regardless of LLC size. Third, this one does not get talked about enough. If anything happens to you, your operating agreement can specify, and it should, what happens to your LLC. Who steps in? Who manages it? Can your family members inherit your interest? Without an operating agreement, this can get messy and expensive and state law dependent in ways you do not want your family to have to deal with. So yes, single-member LLC owners, you do need an operating agreement. So now let's get into the substance of operating agreements. I'm going to walk through the major provisions that belong in every operating agreement. To start with, let's look at ownership and capital contributions. Who owns what? This sounds obvious, but write it down clearly and explicitly. List every member, their ownership percentage, and what they contributed to get that percentage. Capital contribution means what they put in, whether that's cash, property, services, or intellectual property. This section matters because ownership percentage is often the basis for profit distributions, voting rights, and what happens when the business winds down. If it's not written down clearly, you will fight about it later. Also, think about what happens when the business needs more money. Does everyone have to contribute in proportion to their ownership? Can one member contribute more and get a larger stake? What if someone can't or won't contribute? Do votes about all of that have to be unanimous? Your operating agreement should have answers to these questions before they come up. So let's talk about profits, losses, and distributions while we're on the subject of who owns what. How does money move in your business? Specifically, how are those profits and losses allocated among members, and when do distributions happen? Allocation and distribution are two different things, and I want to explain that because a lot of people confuse them. Allocation is how profits and losses are divided on paper, in the books. Distribution is when the money actually goes from the business to the members. An LLC can allocate profits equally but choose to hold the money in the business rather than distributing it. Your operating agreement should specify both the allocation formula and the rules around when distributions happen. This is also where you would address guaranteed payments. A guaranteed payment is when a managing member gets paid for their services regardless of whether the business is profitable. It functions more like a salary. So if Enid is running day-to-day operations and Wednesday is more of a passive investor, Enid might receive a guaranteed payment as compensation separate from whatever profit distributions happen. Now let's talk about the management structure. How will your LLC be managed? There are two basic management structures for an LLC: member managed and manager managed. In a member managed LLC, all the members participate in running the business. Everyone has a say in day-to-day decisions. This works well for small businesses where everyone is actively involved. In a manager-managed LLC, one or more designated managers run the company. Now, these managers might be members or they might be outside people hired to manage. The non-managing members are essentially passive investors. Your operating agreement should clearly establish which structure you're using, who the manager or managers are, and what their authority is. What decisions can a manager make without checking with anyone? What decisions require a vote? Are votes unanimous, majority, supermajority? This is where vague language causes serious problems. Manager has authority to conduct business in the ordinary course sounds fine, and it sounds like legalese until you're arguing about whether hiring a $200,000 employee was ordinary course or not. Along these lines, voting information is crucial in an operating agreement. Who gets to vote on what, and how much does their vote count? In many LLCs, voting rights are proportional to ownership percentage, but they don't have to be. You could have an LLC where everyone gets one vote regardless of how much they own, or where certain members have stronger voting rights on particular issues or on everything. Your operating agreement should specify what decisions require a simple majority, what decisions require a supermajority, like 2/3 or 75%, and what decisions require consent of all members. The more specific you are here, the fewer fights you will have later. Voting information should also contain what happens if there's a tie, especially if there are an even number of voting members. Does one member, officer, or outside party get a tie-breaking vote? Do you flip a coin? Do you draw straws? Do you decide it based on whether or not the Cubs win that day? Do you decide based on whether or not the stars are in a particular alignment? Does a deadlock mean the status quo remains? Now let's take a look on how ownership can change. Can a member sell or give away their ownership interest? If they can, to whom? Under what conditions? This is critically important for multiple member LLCs. If your partner can freely sell their 40% stake to a stranger, you might suddenly be in business with someone you've never met and don't trust. Most operating agreements include a right of first refusal, meaning if a member wants to sell, they have to offer the other members a chance to buy first at the same price and terms they were planning to offer non-members. Some operating agreements restrict transfers entirely, meaning you can't transfer your interest without the consent of all other members. This is very common for small, closely held businesses where the personal relationship between the owners is part of what makes the business work. Now, what happens if you want to bring in a new owner? How does that process work? What vote is required to approve it? Does every existing member have to agree? If you don't address this in your operating agreement, you may end up with a default rule that is not what you intended. Remember Wednesday in Enid, the dispute over whether to admit a new capital investor was one of the things that started their unraveling, and they had no agreed upon framework for how to make that decision. Now here's the section that saves friendships and family relationships, possibly also businesses. A buy-sell provision, sometimes called a buyout provision, is the set of rules for what happens when someone wants out or has to get out. It should cover voluntary withdrawal. What happens if a member wants to leave? Can they just walk away? Are they entitled to a buyout? How is their interest valued? It should also cover death or disability. If a member dies or becomes permanently disabled, what happens to their ownership interest? Does it pass to their heirs? Does the business have the option to buy it back? And it should cover deadlock. If you have a 50-50 partnership and you reach a true impasse, all your tie-breaking provisions have failed, and you just are never going to see eye to eye on the issue, how will you resolve it? Some operating agreements use what's called a shotgun provision or a Texas shootout clause, where one partner names a price and the other partner can either buy them out at that price or sell their interest at that price. It's a pretty dramatic mechanism, but it works because it forces the person naming the price to be honest about what the business is actually worth. The buyout valuation formula is particularly important. Are you using book value, a multiple of earnings, a fair market value appraisal? Agreeing on the formula in advance when everyone is optimistic and the relationship is good is so much better than fighting about it when someone is already ready to walk out the door. So, speaking of walking out the door, what happens when the business ends? What triggers dissolution? Is it voluntary only, or are there automatic triggers like someone declaring bankruptcy, or the business itself declaring bankruptcy, or someone dying? How are assets distributed after debts are paid? Who is responsible for winding up the company's affairs? All that is a lot to consider, but that wasn't an exhaustive list of issues an operating agreement should cover. But those are the ones critically important for most LLCs. Yours will likely have unique issues it must cover as well. Which brings me to the topic of common mistakes. These are the LLC operating agreement mistakes I see most often, and most of them are completely avoidable. Mistake 1, using a template without customizing it. I understand why people do this. Templates are cheap and easy, and money is often tight, especially at the beginning. But an operating agreement is not a document where one size fits all, and this is really something that should be worked into your startup budget. State laws vary. That's why I don't sell a template based in Illinois law that someone in Texas might purchase and think works fine for Texas law when it really won't. Your business structure is unique. The dynamics of your ownership group are specific to you and your situation. The most dangerous version of this mistake is when someone downloads a multi-member template from a free legal website and fills in the names and percentages without really reading it. The template may have default provisions that are completely wrong for their situation, like a deadlock resolution provision that requires buying out a member at book value when the business's actual value is almost entirely in its brand and customer relationships, things that will never show up on a balance sheet. A template is a reasonable starting point, but it's not a finished product. You may be surprised to know that most lawyers won't start with a template you bring to them and just improve on it. It's usually less expensive to have us draft one from scratch than to review one and see what is and isn't in it and how what is in it will work with the provisions that we add. When we start from the beginning, we don't have to waste time on all that. Mistake 2 is not having an operating agreement at all. Now, I know I have already said this repeatedly, but I am saying it again because it is the most consequential mistake on the list. If you have an LLC right now with no operating agreement, please go get one. It doesn't matter if you've been in business for 5 years, 10 years, and everything is fine. You need this document before things stop being fine. I have seen genuine, long-standing friendships end over business disputes that a clear operating agreement would have resolved in an afternoon meeting. Please get the document. If cash flow or time are tight, then get a good template based on your state law as a stopgap. LegalZoom is better than nothing. Just make sure to have a lawyer draft a tailored one as soon as you can. Mistake 3, the agreement is outdated. Your operating agreement was probably written when the business was formed. It might have been perfectly appropriate then, but businesses change, ownership changes, management changes. You bring in new members, you buy out old ones, you pivot your entire business model. If your operating agreement does not reflect what is actually happening in the business, it's a problem waiting to surface at the worst possible time. Review your operating agreement every year or two, and definitely review it whenever something significant changes in the ownership structure or the direction of the business. Mistake 4 is the agreement is ambiguous. Vague language is almost worse than no language because it creates the illusion of an agreement without actually resolving anything. The manager will the manager will receive reasonable compensation. It's not a number. Distributions shall be made periodically. Sounds fine, but it doesn't actually tell you when or how often. Major decisions require approval of the members. Doesn't define major, doesn't require majority, supermajority, unanimous approval. So it's not really a useful clause. Your operating agreement needs to be specific. Real numbers, real processes, real timelines. If you're going to make distributions quarterly, say quarterly. If the manager is going to earn a salary of $60,000 a year, say $60,000. Specificity is your friend, and you can always update these specific provisions later. Mistake 5 is ignoring the what if it goes wrong scenarios. People are optimistic when they start a business, and that's great. They should be. Nobody wants to think about death, disability, divorce, or deadlock when they're excited about launching something. But your operating agreement is precisely the document that should address those scenarios because this is the only time you will be able to agree on the rules without having an emotional stake in the outcome. When I work with clients on operating agreements, I often joke that this is the point where I suck the joy out of their new business because they're paying me to think about all of the things that could go wrong with their business due to my extensive knowledge of things that can, and work with them to prevent them from being major problems. We talk about things like what would cause the most damage if it happened with no plan in place, and then we make sure the operating agreement addresses it. It doesn't matter if you're friends or family. In fact, those are the relationships for which things get the most ugly when something goes wrong. I've seen best friends end up hating each other in tears. I've seen families divided with siblings no longer speaking to each other. That didn't have to happen. Mistake 6 is not getting the agreement properly executed. An operating agreement is a contract. It needs to be signed by all members to be binding. Sometimes there's been a solidly drafted operating agreement distributed to all members. Most people signed it, but one person never did. That person naturally is the one who later disputes its terms. Make sure everyone signs. Make sure you keep signed copies somewhere where you can all find them, and make sure the signatures are dated. Have them notarized if you want to. Mistake 7 is treating it as a one-and-done document. This is related to mistake 3, but it's worth its own entry. Some business owners think of the operating agreement as something you do when you form the LLC and then file it away in a drawer forever and only pull it out if there's trouble. But it's not. It is a living document. Every time the business has a significant development, new members, buyouts, changes in how the business is managed, acquisition of major assets, profits beyond what you imagined, you should be asking whether the operating agreement needs to be updated or amended. Ask your lawyer. Mistake 8 is ignoring the intellectual property. You knew I was going to go there, didn't you? This is one that is, yes, specific to the kind of work that I do, and I flag it because it trips up so many small business owners. If members are contributing intellectual property to the LLC, brand names, inventions, creative work, software, trade secrets, your operating agreement needs to address the ownership and licensing of that IP very clearly. Who owns the IP? The LLC or the individual members? If it is the LLC, what happens to it when the LLC dissolves? If a member leaves, do they take their IP with them? Can they use it to compete with the business? Who's in charge of renewal and maintenance? Operating agreements that are completely silent on IP while one member contributes a trademark brand name to the business, then leaves the business, end up with a dispute over the brand name being enormously expensive and complicated in ways that have nothing to do with how good their attorneys are and everything to do with the fact that they never had written and everything to do with the fact that they never had written down who actually owned the name. Don't let that be you. Here's what I want you to do with what you've just learned. If you have an LLC and no operating agreement, this is at the top of your list. Stop treating it as something you'll get around to eventually. Get it done as soon as you possibly can. If you have an LLC and an operating agreement you downloaded from the internet and haven't really read it. Actually sit down with it and go through it. If you don't understand a provision, ask an attorney to explain it. If it doesn't address your actual situation, get it updated. If you have a multiple member LLC and your operating agreement does not have a clear buy-sell provision with a valuation formula, get that fixed. The time to agree on how you would value a buyout is when you don't need to do one, not when you do. If you have a single member LLC and thought you didn't need an operating agreement, I hope this video changed your mind. If not, go back and watch it again. And if you're about to form an LLC with partners or on your own, please consider talking to an attorney before you finalize anything. Not because you can't do any of this yourself, but because the decisions you make up front are so much less expensive to get right the first time than to undo later if they can be undone. Now let's look at the questions I hear most often. Do I have to file my operating agreement with the state? No, and this surprises a lot of people. In almost every state, your operating agreement is a private document. You don't file it with anyone. You keep it in your own business records. This is different from your articles of organization, which you do file with the state when you form an LLC. Can I use a free online template for my operating agreement? Technically, yes, you can, but understand what you're getting and not getting. Free templates are generic. Even paid templates can be pretty generic. They are almost always not written for your state's specific laws, and even if they are, they're not written for your specific business. For a very simple single-member LLC with no unusual circumstances, a template might be an adequate starting point. For a multiple-member LLC, especially one where the members are contributing different amounts of money, time, or intellectual property, I strongly recommend working with an attorney. My LLC has been operating for 3 years with no operating agreement. Is it too late? It's never too late. Go get one. The fact that you have been operating without one means that there may be some ambiguity around some things like what each person's contributions have actually been and what the current arrangement really is, and an attorney can help you document what has happened and build the agreement around your current reality. It's more work than doing it at formation, but it is absolutely worth doing. My business partner and I are also married. Do we still need an operating agreement? Oh, yes. I know it feels overly formal, but married business partners have all the same potential for disagreement as any other business partners, and the added complexity of divorce law and couples estate planning on top of business law makes the operating agreement more important, not less. If you live in a community property state, this is especially true. What's the difference between an operating agreement and a partnership agreement? A partnership agreement governs a general partnership or a limited partnership. An operating agreement governs a limited liability company or LLC. They do serve similar functions. They're both the internal governing document for the business entity, but they are different documents for different types of business structures. If someone hands you a partnership agreement for your LLC, that is a mismatch worth paying attention to. What happens if our operating agreement conflicts with state law? This is a great question, and of course, it depends on the provision and the state law. Some state LLC statutes set default rules that your operating agreement can override. Other provisions are mandatory. They're set by law and cannot be changed by private contract. In general, LLC law gives you a lot of flexibility, but there are limits. An attorney who knows your state's LLC statute can tell you which provisions you can customize and which you cannot. Can we amend our operating agreement after the fact? Yes. Your operating agreement should include a provision Your operating agreement should include a provision describing how it can be amended, typically some vote threshold of the members. As long as you follow that process, you can amend it. If your operating agreement somehow does not address amendments, you would typically need unanimous consent of all members to make changes. Does my operating agreement need to be notarized? In most states, no. Signatures of all members are sufficient. There are some narrow exceptions. For instance, if your operating agreement involves transferring real property into the LLC, you may need notarization for that specific transaction. This is state-specific and worth confirming with an attorney. My business partner and I have been friends for 15 years. Do we really need all this? Yes. The operating agreement is not a sign of distrust. It's actually the opposite. It's the two of you saying we trust each other enough to be honest right now about what we each expect. Let's write it down while the relationship is good, so neither of us is ever put in the position of relying on the other person's memory of a conversation we had 5 years ago. The friendships and partnerships that survive business disputes are the ones where there was a clear agreement from the beginning. How much does an operating agreement cost? Well, it varies a lot depending on complexity and the attorney and the area of the country that you live in. For a simple single-member LLC, it might be a few $100s if you don't live in a big city. For a complex multi-member LLC with detailed buy-sell provisions and intellectual property assignments, it will be much more. Many attorneys, including me, offer flat-fee business formation packages that include the operating agreement as part of the package. Now, the cost of getting it right up front is always a fraction of the cost of litigating or even negotiating a dispute later. If this video was useful to you, please share it with someone who's starting a business or who you know is already running one without an operating agreement in place. This is genuinely one of those foundational documents that can prevent catastrophic outcomes, and the more people who understand they need one, the better. I also have a free checklist linked below. It lists the provisions your operating agreement must cover, and you can use it whether you're building one from scratch, reviewing one you already have, or preparing to meet with a lawyer. If you have questions about your specific situation, I do offer business law consultations. I'm licensed in Illinois, so if you are an Illinois business owner, I can work directly with you on your operating agreement. Consultation link is below. If you're outside Illinois, ask your trusted business associates or friends for a referral, or check with your state or local bar association. Thanks for watching or listening. I'll be back next week to talk about part 2 of intellectual property succession planning, which covers the digital estate, what happens to your social media accounts, domain names, and online presence when you're gone. I covered part 1 last week. I'm Julie King with King Patent Law. If you're ready to protect your brand and business, book a consultation at kingpatentlaw.com. Avoid the legal horrors and keep rocking your IP. This is not legal advice, and I'm not your lawyer. For advice about your specific situation, consult with a licensed attorney. This does contain attorney advertising material. Firm address and contact information are available at kingpatentlaw.com.